The views and opinions expressed in the documentary are those of the speakers or authors and do not necessarily represent the views and opinions of the law firm. Due to the social nature of this broadcasting channel, the documentary may be copyrighted by another entity or person. This channel honestly claims no copyright to the said content. The broadcaster of this channel cannot be held accountable for the copyrighted content. The creator of this documentary is a messenger and sharer of information and cannot warrant the accuracy of copyrights or completeness of the information in the documentary. This documentary has been created only for informational purpose and is not intended to constitute solicitation, invitation, advertisement or inducement of any sort whatsoever from the creator or any of the speaker to solicit any work in any manner. If you have a complaint about something or find your content is being used incorrectly, please contact the creator of this documentary prior to making a copyright claim. Any infringement was not done on purpose and will be rectified to all parties' satisfaction. The framers of our constitution had prescribed for democratic governance supported by an effective legal system to achieve the socio-economic transformation of India. The constitution in its preamble embodies justice in all its forms, social, economic and political. It imposes a duty on the state to secure the operation of the justice system in a manner that promotes equitable growth, fairness, rule of law and universal access to justice. International Bar Association's International Principles on Conduct for the Legal Profession says that lawyers throughout the world are specialized professionals who place the interest of their clients above their own and strive to obtain respect for the rule of law. They have to combine a continuous update on legal developments with the service to their clients, respect for the courts, and the legitimate aspiration to maintain a reasonable standard of living. However, the preamble to the UN Basic Principles on the Role of Lawyers says that an independent legal profession is integral to upholding the rule of law, whereas adequate protection of human rights and fundamental freedoms to which all persons are entitled, be they economic, social and cultural or civil and political, requires that all persons have effective access to legal services provided by an independent legal profession. In addition to that, Principle 12 of the UN Basic Principles on the Role of Lawyers says that lawyers shall at all times maintain the honor and dignity of their profession as essential agents of the administration of justice. However, Principle 15 of the UN Basic Principles on the Role of Lawyers says that lawyers shall always loyally respect the interest of their clients.
Hi Nishchal, my name's Taylor West. I am a general corporate attorney working at Latham & Watkins in New York City. I've been working there for almost a year and it's been really cool. My typical practice focuses on investment funds and environmental work. So there's a few questions here for me based on United States ethics. So the first question is, what are the legalizations, codes, etc.? So the main source of ethical rules in the United States is the Model Rules for Professional Conduct, and those are put out by the American Bar Association. So to comply with those, all lawyers have to not only take an ethics class during law school, they also have to pass the Multi-State Professional Responsibility Exam, which is the MPRE. And then they also have to do continuing legal education classes once they're barred attorneys, and some of those credits will be for ethics credits. So what ethical issues have been flagged in the US by advocates? One of the main focuses is wanting to avoid conflicts of interest. That's one of the biggest emphases within our ethics curriculum. Also general things like honesty, confidentiality, not mixing funds, for example, is really important. Those are sort of the main things that we cover in our ethics classes that's important to know, especially because lawyers will be handling a lot of people's money and they'll be managing a lot of confidential information. So that's really what we focus on. And then what factors do I consider before taking a case? So it's a little bit different for my practice because I work at a large law firm. So generally I'm assigned cases or deals from my supervisors, and I take those based on my availability. The firm does a conflicts of interest check before they take on any new clients, so that's one way that they make sure there's no conflicts of interest. I don't actually know a lot of the finer details about how the firm takes on cases and takes on matters, other than that they are very, very strict about their confidentiality and their conflicts. Then the question was if I do any pro bono work, and I do. I actually do a very large amount of pro bono work. Primarily I do immigration work. So I work with clients who are coming to the United States seeking asylum, and I work with clients who are already in the United States who were in relationships that became abusive, marriages that became abusive, and then they're able to petition for their own citizenship if they meet certain requirements. So those are the main things that I do as far as pro bono goes. I've done a little bit of environmental pro bono as well, but that's about it. And, you know, really my factors in taking that on is just that I think pro bono is extremely important. I think it's important to provide good quality legal services to people who otherwise wouldn't have access to those services. And I think we have a lot of really worthy pro bono clients, so I like to be able to help with that. And then the last question is if I've ever faced an ethical dilemma in my profession. Fortunately, in the first year that I've been working, I haven't. I know that they crop up, people have, and at my firm, as is pretty typical in law firms in the United States, there's an ethics committee or an ethics board, you know, some sort of in-firm organization like that, and it's very typical to bring those ethical concerns to that committee. So, like I said, fortunately, I haven't had any of that happen yet, but there are systems in place to try and make sure that if ethical issues do arise, they are dealt with in accordance with the rules. So I hope this has been helpful.
For question number 1, in the United States, each individual state has its own ethics code that the attorneys practicing in that state have to follow. Although these ethics codes do vary from state to state, there are some underlying similarities between them, so it's not completely different between, say, Massachusetts and New York. There's also a federal ethics code that you have to follow if you're practicing in any federal court like the U.S. Supreme Court. This federal code, again, shares a lot of similarities with the individual state codes, so although there are differences among the ethics codes, the general themes tend to be fairly similar among the states as well as the federal government. For question number 2, what ethic issues have been flagged? There's tons and tons of ethics cases in the United States. This is something that gets brought up a lot in the courts. One of the really common issues is what evidence you have to share with the other side. So if you're in a litigation with another party, if you have some really great piece of evidence that you would like to keep secret, a lot of times you actually have to share that with the other side, so that way they're fully informed of the case before them. So you see a lot of ethics cases come around where an attorney didn't share something with the other side that they were supposed to, so that side's not fully informed. For question number 3, what factors do I consider before taking a case? One of the major things that I consider are whether I have time to really dedicate to the case, as well as if I have the skills to be able to be a true advocate in that case. Even though something might sound really interesting and like a great case, if I don't have the skill set for that, I don't want to take the case on and not being able to represent a client to the fullest extent. Another thing that's really common in the United States is most law firms have what are called conflict procedures. So the law firm will look if your law firm is representing a client whose interests are adverse to a new client that you want to take on. And if you're already representing a client with adverse interests, then you won't be able to take on the new client, even if you otherwise would have wanted to represent them. For number 4, I do take on many pro bono cases. It's something that I really enjoy doing. When I take on a pro bono case, usually the thing I think about the most is, again, do I have the skill set to help this person, and do I have the time to help them? Most of the pro bono cases that I take are in family law, because that's an issue area that I really enjoy working with. So at this point, I've developed a pretty good wealth of knowledge in that area, and I feel like those are cases that I can really help someone with. And for number 5, have you ever faced an ethical dilemma? I actually did recently face an ethical dilemma. I was representing a pro bono client who really wanted us to go to court on a particular issue, but me and my co-counsel did not believe that going to court was in her best interest in this case. So we had to sit her down and talk to her about why we didn't think that was in her best interest to go to court. And even though our client really, really wanted to go to court over this particular problem, we knew that ethically it didn't make sense to take her because we knew that the outcome would ultimately be adverse to her. So that was definitely a dilemma that we had to tell our client that we couldn't do what she wanted us to do because ethically we didn't think it was in her best interest.
The legal profession in India, therefore, has a duty to assist the state in establishing an efficient judicial system, secure citizens' access to justice, alleviate inequalities and unfairness, and ensure that all people possess the basic material and political rights needed for full participation in the life of our society. Highlighting the importance of the responsibilities of legal profession, the ex-President of India, Shri Pranab Mukherjee, has observed that every legal practitioner must be cognizant of the responsibilities that come with being admitted to practice and with each appointment and level of office. The philosophy of the rule of law stands on the shoulders of lawyers, the link between the citizen and the system of justice. If this vital link were to fail, our system of justice would bring to a halt in spite of every other measure of reform.
Hi Nishchal, and hello to everybody back there in GNLU. My name is Srisha and I am a graduate of batch 2018 of Gujarat National Law University, as a lot of you are aware. I am currently working as a legal associate at Mariappa MS and Associates in Bangalore. So the kind of work I am involved in features traditional civil litigation. It also involves a lot of check bounce cases because we are empaneled with a lot of banks. So having given you a primer as to what work I do, let me now move on to the questions that have been posed to me by Nishchal. So the first question related to legal ethics that he has posed to me is, what factors do I consider before accepting a case? Now I may be a little ill-equipped to answer this question because I have not started my own practice as yet. I can enlighten you people about what I have observed from working for the past 1 year with my senior. So there is no hard and fast rule as to what kind of case you should be accepting. The main reason behind this is under the Constitution of India itself, one gets the right of legal representation. So no matter what you feel about any person or how good or bad he is, he does have a right of legal representation before the courts of law. So you would technically not be wrong even if you took up the case of defending a hardcore criminal who has had a proven track record of murdering many people in the past. However, now legal ethics is a mixture of whatever professional ethics or the code of conduct that the Bar Council of India has set down and whatever personal ethics you have. It is a mix of that. So a lot of advocates, you can see a lot of advocates not taking a certain type of cases because it hurts their conscience. It is all a part of personal perception. So now, since this question is personal, what factor I would be looking at before accepting a case? I would say that I will first look at whether the client is truthful to me. Now there are a lot of clients who come and they start lying to the advocate itself because they fear a backlash, or they might think that the advocate may think bad of me or whatever. So they try to project a good side of themselves. Now that is not necessary, because as an advocate there is this client attorney privilege which you are bound by. So whatever he says to you remains between you two. So the first thing that I would expect from a client is honesty. Now, if you're not honest to a lawyer, how can you be honest to anybody else? Now, if he honestly accepts that yes, he has committed this crime, now I may look at the legal loopholes and see what sort of defense I may put up before the court of law. I might tell him that okay, this case might not stand in the court, however, I'll try my best. Now, what I would be looking at is an honest individual. Secondly, I would also look at the fact that whether he would be able to divulge full information to me, whatever is required for the case. Now, firstly he has to be honest, secondly he has to divulge all the information necessary to run the case properly. Okay, so now I will move on to the second question. What would an advocate consider to be a reasonable fee? Again, this is not fixed, since advocacy is a service oriented profession. You may choose your own charges for whatever service you are providing to the client. Now, since I am a beginner and I might not have a certain level of exposure in handling matters, if the client is ready and willing to appoint me as his advocate, I would fix a reasonably lower fee in comparison to, let's say, a senior or my senior himself. But as and when your profession develops and you develop a sort of reputation, it is advisable to increase your fees proportionately to the clients who are willing to pay, obviously. Now, your service does not come free of charge. You have to attach a premium to your service. Otherwise, people will recognize you as a lawyer who takes all sorts of cases and who is even willing to forego his fees or whatever, even if the client is able to pay. Now, in such a scenario, people will start taking you lightly. Now, that is not advisable, because you as an advocate has to build a certain level of reputation in the industry. For that to happen, you need to attach a premium to your services. So, a reasonable fee is what you expect to be reasonable for the kind of services you provide. And if you want to reduce the number of clients but increase the quality of work, more fees is but a natural consequence. So now, third question would be, what is the driving factor behind taking up pro bono cases, and do you take up any pro bono cases? So, pro bono is something you do as a service to the society. So, you have to consider whether the case has to be taken up pro bono or whether you have to charge a fees based on how the client is and what his financial situation is and how dire is his necessity. Let us say a client is coming to you because his fundamental rights have been violated by the state, but he is not in a position to pay you a lot of money. Now, as a responsible citizen of the country, it is your duty to take up pro bono. But then there is also one more factor which you need to consider, is whether you will be able to sustain the whole litigation process. Now, I being a low paid counsel right now in a litigation firm cannot afford to run a pro bono case right now. However, if and when I develop a good practice, let's say 5 years down the line, and I have the necessary financial power to help a client who is in need, I will take up a pro bono case. There is no problem in that. Which is why one says that advocacy is a highly individualistic profession. You can choose what you want to do. You have a lot of freedom, which is why advocacy is a kind of preferred profession for a lot of bright youngsters nowadays. So the next question is, what do you say about very meager salaries being given by the seniors? yeah, when you do litigation work, it is this traditional mindset of a lot of senior advocates that you have to earn your bread and butter the way up. So you have to earn your money by hard work, by putting your sweat and blood. I agree to all of that. However, I do not really agree with the logic that our seniors used to pay us a lot lesser than what you are being paid now. So you have to adjust with whatever you are getting, because even as you can see, a lot of advocates make like a bomb at the bar, and if they pay their associate, let's say 5,000 or 10,000 more, it doesn't really pinch their pockets. On the other hand, it encourages a lot of bright youngsters to come to the profession. Now, with a meager salary of like, let's say 10,000 to 15,000 in Bangalore, you can't really survive. But if your parents support you, and with initiatives like Glass in GNLU, a lot of young advocates are finding their feet in the bar. So that's a good thing. I would also request the Bar Council of India to, give a sort of stipend to the young advocates who have just entered the bar. That would encourage them to work more, and that would encourage a lot of young minds to come into the profession. Now, the last question is whether I have faced any ethical dilemma while working as an advocate. Yes, indeed I have, because ethical dilemma is, let us say, almost a daily feature in the life of an advocate. You have a lot of clients whom you know to have committed a crime, let's say, or maybe harassed their wife or beaten up their children or whatever. But then they still have a lot of strong legal points before the court. They might even go on to win the case. Now, knowing that your client has actually done this, but you still are working for him because then you would be going against your professional ethics. So this tussle between professional ethics and moral ethics is like a daily phenomenon in the life of an advocate. It is something that you have to come to terms with, and you have to work out your own practicable solution to the whole problem and see how you move forward. Now, that is only the way to move forward in this profession. If you cannot find a balance, then it would be a pain for you. Daily practice would be a pain for you, because you're obviously trying to defend criminals. It's not an easy task. So when you get into litigation, I would want you to carefully consider all these aspects and then decide. So yeah, thank you. Have a nice day.
Members of the legal fraternity have been contributing immensely to the emergence and growth of this nation. But the dynamic nature of our legal system and societal needs compels a constant reflection and self-introspection of role and responsibilities of lawyers. In this regard, increased attention to research and deliberation of these issues on professional responsibilities can be useful to meet the future needs.
This is Kavin Naran. I'm a practicing advocate in Delhi, and I practice in the Supreme Court of India, Delhi High Court, and all other courts in Delhi. I practice in the field of civil, criminal and corporate litigation, and I have been practicing for more than two years now. Before going into the questions that you have asked me, I would like to make a small point. As I started with my introduction, I'm a practicing advocate. What that means is that basically what we forget, or what the clients forget, what a layman forgets, is that it's a profession where we practice every day. Nobody in the profession, whether it be a senior advocate, whether it be even a judge, knows the law 100%. everybody interprets the law in according to himself, and everybody learns a new thing every day. So the ocean is very vast, and we take a bucket out of it every day, and that is how we move ahead in this profession. That is why that is what I wanted to say, that we are still in the process of that we practice the law and we are not experts at it. Now coming to the question that you have asked me. The first question that you have asked me is that what are the factors considered before accepting a case? So it's a very subjective topic because there is no straitjacket formula to see whether you will accept a case or not. But broadly speaking, there can be 2 or 3 factors that I can call out. The first factor will always be that whether the matter that is involved satiates your intellectual hunger or satisfies you intellectually, because as a young counsel, as a counsel with early days in the profession, what I personally try to do is to learn as much as I can in these initial few years. So the attempt is always to try and do new kind of stuff. The attempt is always to try and learn out of a matter, and that is my primary concern. Then secondly would always be that your time is justified by the returns that come in. It's a lesser of a consideration, but still one of the considerations. The other thing, and a very important thing, will be the transparency and the trust that the client has on you. Because if the client does not trust a lawyer, then it becomes very tough for a lawyer to handle that matter further. And so the trust factor and the transparency that the client has is very important consideration. See, when we are at practice, when there's a dispute, one or the other party will have some fault, or probably both the parties will be at fault in some way or the other. Now, you need your client to come out to you, open up to you 100%, so that you can formulate a strategy, so that you can formulate a way to defend him in court and in front of the other party. So trust and transparency will be very important for me to take a matter or carry on with a matter. Second question that you have asked me is about the fees and what is a reasonable fee for a matter. So again, this is a very subjective topic. Every lawyer, as you know, has a different fee, and a reasonable fee for every matter is different. As I said, in the initial few years, my attempt is to learn as much as I can. Justice Uday Umesh Lalit, who's a sitting Supreme Court Justice, in a conversation had once told me that when we practice, the first 10 years of our practice, we earn 10% of the amount we put in. In the next 10 years, that is 11 to 20 years into the practice, you earn 100% of the amount or time that you put in and the effort you put in. And the rest of the years, the forthcoming years after you're 20 years into the practice, you earn 10 times the amount of time and effort that you put in. So in the initial few years, my attempt is always to learn as much as I can, and the reasonable fee is only a fee that can justify my time that I put into the factor and help me earn a decent bread and butter. The next question that you have asked me is whether I take pro bono matters or not, and what are the driving factors for it. So yeah, answering your first question, yes, I do take pro bono matters. The driving factors for pro bono matters are, one, the need and necessity of the client. If the client does not have the pockets to, or if the client is unable to pay the fees, then that is the primary concern. And more than that is what the story is, or how much am I moved by the story of the client. If the litigant has been harassed and is facing difficulties on a daily basis, then that becomes my driving factor, and that is what makes me take the pro bono matters, or defend that client or represent that client in court and do my best for the client. Having said that, again, coming to the reasonable fee aspect of it, you have to consider that you are satisfied somewhere or the other, and so when you take up a matter, what I go into is that if I take up a matter, I take it in a manner, I deal with it in a manner that it is always to the beneficial interest of the client, and it is always looking for a solution to the client's problem. So all these factors have to be considered when I even take up a pro bono matter or the fee element. The next question that you ask is pretty interesting, and what is the salary like for the junior lawyers or junior practicing counsels in the country? So this topic is like one of the hot burning topics in colleges, that is ragging. Everybody says the same thing, that we rag because we were ragged earlier. Our seniors ragged us, and it's a tradition that has been going on. Similarly, in law practice, the problem is that senior lawyers, people who are seniors now, were not paid when they were juniors, and they think that is how it goes on. A very important factor that is associated with it is the prestige of the lawyer. So the senior lawyer always has the point of view that you are actually learning under the aegis of the senior lawyer, and you're not an expert that you should be paid much. I disagree with it, having faced that in my profession as well. I disagree with it. I think a person should be paid according to the work he does, according to the way he contributes in the office, in the chamber. And so if a junior lawyer who's freshly out of law school can contribute in a matter in a significant way, and I get a decent fee out of it, or if a senior lawyer gets a decent fee out of it, then some portion of the fee should always go to the junior counsel. That is what I consider. And fortunately, there are new lawyers coming up who are paying good, who understand the problem, who have faced the problem earlier and who understand the problem, and are trying to do their best for junior lawyers coming up. So that way the field is improving at a small pace but a significant manner. So the next question that you asked is whether I have faced ethical dilemma in life, in the profession. Most definitely I have faced ethical dilemma in the profession, especially early on in the practice, because there will be things that you'll have to do that you don't want to do, that are technically not as per the law. There will be clients who will force you to do things, and you will, in the initial few days or initial few months, always have that ethical dilemma of whether signing a paper, of whether making a fake signature of the client or not, or making a fake signature of your senior or not, or making an argument that, or stating a fact that you know is not certain, but there is no way to find out that it is not true. Making a submission that you know is not true, but there is no way of finding out whether it is true or not. It's not documented. Such dilemmas will be faced by a young lawyer every day in his life, and fortunately or unfortunately, you start getting used to it. Where I draw a line when I am in such a situation is that when we talk about ethics, again, legal field has you are responsible to two things. One, you are responsible to the client that you represent. So your activity should always be in accordance with the client's best interests, and that is part of the legal ethics. And secondly, you are also responsible to the profession. You are also responsible to the bar. See, a lawyer is a officer of the court in the first place. So being an officer of the court, my responsibility is also towards the law, and I make it a point to not take a step or to not go beyond a certain line that I have drawn in my head. And that line basically is that what is acceptable and what is morally acceptable and what is not. So again, this is a very subjective topic to talk about, but you face ethical dilemma in life on a daily basis in the legal profession, and you have to make your call on a daily basis, on a situation to situation basis, that whether you are in a position or whether you shall go beyond that line or not. Just concluding my observations first, I would like to thank you to give me the opportunity to talk about the subject, and I hope my answers have been satisfactory to you. Thank you.
In the contemporary context, a lawyer must be committed to fulfill his duties towards his client, court, and the Constitution. He must embody a philosophy to uphold the rule of law, transparency, and democratic ideals. He must discourage compulsive litigation, assist the court to curb unnecessary delay, and expedite judicial proceedings, explore non-adversarial forms of dispute resolution, and strictly adhere to rules of professional conduct and etiquettes. He must participate in professional development programs and engage in updating his legal and professional skills, actively engage in the free legal aid programs, and undertake pro bono public services. This will help the judicial system to meet the unmet needs of the underprivileged sections and promote the socio-economic transformation of this country as envisaged by the Constitution of India. Let us remember that legal profession is the only profession to find the pride of place in the Constitution of India. It is therefore of paramount importance that our judicial system has a steady pool of talented, dedicated, and qualified legal professionals who can serve at all levels of the system. A good legal education system can only ensure the same. It helps to prepare professionally competent and socially sensitive law graduates who in due course engage the bar and the bench. Legal educators have to give due attention that along with imparting legal knowledge and skills, the students are also exposed to the moral duties and ethical responsibilities of a lawyer. Emphasis has to be on research and teaching of professional ethics. However, professional ethics are key to ensuring an independent, competent, effective, and accountable legal profession. Where comprehensive rules of ethics or professional conduct exist, they should ensure that lawyers are required to follow client care procedures, act in the best interest of the client, and fulfill their duties as advocates. Ethics can further instill principles of fairness, honesty, and integrity in the way that lawyers conduct themselves and strengthen public confidence in the administration of justice. Nevertheless, the important role of lawyers as ultimate guardians of the law means that the legal profession has a huge responsibility in ensuring that rules of ethics are developed, that lawyers and the public are educated about ethics, and the ethics are made effective through disciplinary mechanisms. Without ethics, trust in the legal profession and as a result, the justice system itself is undermined.